Hello everybody, welcome to my video, courtesy of www.freedqinfo.com. In this video I'm going to be discussing and analyzing illegal disqualification letters and compare them to the NOPD, which is the Notice of Proposed Disqualification. So here, as you can see, there's just a whole bunch of disqualification letters. So let's just take a look at the first one right here. This one is dated 7/19/1985. All right, that's one of the oldest ones I was able to find. And you notice here it starts off with, "Dear candidate, I regret to inform you have not met the medical requirements for the position of police officer. This determination was based on evaluation of psychological test and interview, which found personality traits incompatible with unique demands and stresses of employment as a New York City police officer." And then it talks about, "Please take notice that you can appeal from your disqualification by writing within 30 days to the NYC Civil Service Commission." All right. So let's fast forward into the future, 2008, for this guy, Edwin Lopera. And it's pretty much the same thing. "I regret to inform you that you have not met the requirements of position of police officer, blah, 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 blah." So you could actually look at these on the PDFs on my website and look at them very, very carefully. Pretty much what you're going to realize is they're all the same. Okay, all of these are the same. The only difference is, of course, the date and maybe the name of the candidate, and that's pretty much it. All right, so now let's take a look at the NOPD. All right, now here's the big thing. This is the difference. It starts off by saying this is a Notice of Proposed Disqualification Police Officer, NOPD. So let's read. "Please take notice that after a psychological evaluation, the New York City Police Department, NYPD, has made a preliminary determination that you are not psychologically suited to unique demands and stresses of employment as a police officer pursuant to," look at this, "Civil Service Law Section 50.4A and or 50.6, and is proposing to disqualify." That's a huge difference in terminology here. All right, and they talk about here, "It's important to know that this evaluation is limited to specific demands and is not a reflection on your suitability for other employment or finding that you have psychological disability or diagnosis." The reason that they're saying this is they're trying to avoid ADA, that's the Americans with Disabilities Act, liability for the psychological testing and so forth, which I will argue in a separate video that they are in fact in violation of the ADA. So let's go over here. "You now have the opportunity to submit additional information to demonstrate your psychological suitability for the position." So note, that's the main difference. Before, in the old DQ letters, you were outright disqualified. All right, let's go back to 1985. It says Notice of Determination. They've pretty much said, that's it, you're disqualified, have a nice day. All right. But over here, they're telling you, okay, you now have the opportunity to submit additional information to demonstrate your suitability for the position, and they are saying that any information you submit will be considered. I will also argue that this is not true. That's another video that will be coming up shortly. But again, let's look at the terminology here. Once you have been disqualified, okay, so basically this letter is telling you, the NOPD that is, that, listen, we're about to disqualify you, we're going to disqualify you, and we're telling you in advance that we're going to disqualify you, but we're giving you a chance before we disqualify you to submit additional information so that maybe, we'll consider it and maybe we'll qualify you. That's not going to happen, but at least they're telling you, they're teasing you with the possibility that it might happen. All right, so they're telling you here to submit a written statement and or medical documentation. All right, so notice that the NOPD is actually 3 pages long. The previous illegal disqualification letters were all one single page, and that was it. You had to go and appeal to the Civil Service Commission. But here, this is a totally different story. All right, so they talk about the psychological services file, and they give you directions on what to do. The directions are pretty much similar, if not identical, to the illegal DQ letter, but the thing is, they're pretty much giving you one, advance notice, and that opportunity to submit information. Okay, that way they could be compliant with what? With Civil Service Law Section 50.4. All right, because the Civil Service Commission has previously hammered NYPD when issuing the reversals that they were failing to do this. So now NYPD is finally starting to comply. Of course, this also has to do with all the complaints and paperwork that I filed with Civil Service Commission, Corporation Counsel, DCAS, and DOC regarding these illegal disqualifications. All right, so notice this, applicant withdrawal request after NOPD. So basically what they're telling you here is if you got this NOPD, you can withdraw your application. And here's what I want you to pay attention to right here, NYPD 102813. That's October 2013. So basically NYPD has known about this since 2013. All right, this is coming from the PSB, which stands for the Personnel Services Bulletin issued by DCAS. There will be a separate video talking about that, so just be patient, and when that video comes out, I will have a detailed explanation of the PSB and its implications. Now, let's take a look over here. Notice, this is a document issued by the Civil Service Commission that they're basically telling applicants who are appealing that, hey, if you want to withdraw your application, you can. But look at this line right here. This opportunity, meaning the opportunity they're talking about is withdrawing, is being provided to candidates with pending appeals as an interim measure while NYPD and Civil Service Commission and New York City Law Department review and revise the process for psychological disqualifications. I mean, this basically says that, hey, we don't know how to properly disqualify people at this point. So instead of bothering to do it properly, we're asking you withdraw so, you know, we don't have to deal with it. That's what this means, all right? And here, you know, they're basically saying, you know, you could withdraw your application and, you know, that, let's see, there is a line here. Okay, if you choose to do so, you are not waiving any rights or privileges that you are otherwise entitled to under civil service law. This is not true because if you got the illegal disqualification letter, you are actually protected by Civil Service Law Section 50.4. So if you withdraw, you're actually giving up those rights when in fact the Civil Service Commission should be enforcing 50.4 on your behalf, like they did for several other applicants. All right, now this right here, it's a very important document. This is a vintage NOPD. Notice here, Notice of Proposed Disqualification. All right, this one is dated 2011. It's Form APD 63, and I talk about it in my argument. So this is a one-page document, and it's totally different from the new NOPD. Now, what's different about it? So let's read it. The purpose of this notice is to inform you in writing that you will be disqualified. Again, you will be disqualified. It doesn't say you are disqualified. It doesn't say we have found you disqualified, but it says that you will be disqualified for the position of police officer if you do not respond to this notice. And it says information contained in this notice is important to you. You should read it carefully. The reasons marked below apply to you. So check it out. Number 2, background investigation character, and some boxes checked off, and it says unsatisfactory prior private employments and other driving record tab summonses and debt. So basically this document is telling you exactly why you were disqualified, and it's giving you notice that, you know, you can resolve these problems. And if you fail to resolve these problems, you will be disqualified. So again, it's telling you in advance, look, these are the issues. This is why we are going to disqualify you. And if you don't resolve these issues, we will disqualify you. But again, so somebody who has gotten this letter had the opportunity, as per Civil Service Law Section 50.4, to basically submit evidence and arguments against the intended disqualification prior to that disqualification becoming final. That's a key and major difference. Now, let's take a look at the Department of Corrections NOPD, because it's actually different than NYPD's version. So let's check it out. Again, it says Notice of Proposed Disqualification, and it's pretty much the same thing. But they make the choices, they give you 3 choices. It says withdraw your application, self-written statement, 3 professional report. That's pretty much similar. And again, their NOPD is also, as you can see here, 3 pages long. All right. Now, this is the page that I really want you to pay attention to right here. This is the 3rd page, and it says correction candidate, exam list number, etc., etc. Right here where I have underlined in purple. All right, this cover letter is being sent pursuant to Personnel Services Bulletin 100-10R issued by DCAS in 2013, which governs background, medical, and psychological disqualifications. So basically, DOC has known about this since 2013 because, again, pursuant to PSB, Personnel Services Bulletin 100-10R, that was issued in 2013, they were supposed to be issuing these NOPDs. All right. Now, the NOPD technically was supposed to be issued since the beginning of time because of Civil Service Law Section 50.4. It's just that DCAS officially, created the PSB telling agencies, hey, in order to be compliant with 50.4, this is what you have to do. All right. Now, again, corrections, NOPD, 3 pages long, all right? Note here, since 2013, they knew about this. All right, so now let's take a look at my disqualification letter by Department of Correction. It's dated February 14, 2013. And as you can see, upon designation of Pre-Employment Psychological Services Unit, NYC Department of Corrections found you psychologically not qualified. All right, so again, this right here is the identical illegal DQ letter, pretty much similar and identical to the NYPD version. All right, it's nowhere near the NOPD. It doesn't satisfy the requirements of Civil Service Law Section 50.4. It's basically illegal. Once they issued this illegal DQ letter, they violated Civil Service Law Section 50.4, and I should have been given the protection of this law like some other candidates. But not just myself. I'm talking about literally tens of thousands of people. Going back to this 1985 DQ letter, think about this. 1985 till, let's just say 2015, that's 30 years of illegal disqualification letters. I mean, just think of the sheer scope of how many people were disqualified. All right, there's an article on the internet where it basically says that in 1997 alone, there were 920 disqualifications. So that's almost 1,000 disqualifications in just 1 year. If you multiply that by 30 years, you're looking at 30,000 illegal disqualifications. Now, let's just be conservative and do half of that number. That's 15,000 disqualifications. Do you see how ridiculous this is and how many people were just affected? I mean, talk about lost job opportunities, careers destroyed, never able to take off, folks who are not given the opportunity to defend themselves against these illegal disqualifications, except for only a handful of people that were chosen by the Civil Service Commission. So again, I'm going to take a break right here, and I will continue with more information and more videos. Thank you for watching.